afternoon. Thank you very much. I would like to start giving thanks to the Central European Academy for organizing this conference and allowing me to be here with all of you. Thank you very much. The topic I'm going to address today is the Mayorazgo. The Mayorazgo was a legal institution in which patrimonial and inheritance aspects converged. On the one hand, it was a particular form of property. The holder of the Mayorazgo benefit from the fruits of the related assets, but have no right to disposal over them. He could not alienate, donate, or mortgage them, nor dispose of them mortis causa. Moreover, it was a system of succession. On the death of the holder of the Mayorazgo, the entire estate had to be transmitted in diviso to a single predetermined person. That generally was the first-born male. And this is the origin of the concept of Mayorazgo, Major Natu, the eldest by birth. The purpose of the Mayorazgo, according to the formula of Diego Pérez and Luis de Molina, is to preserve the house and not to dissipate or diminish the good and estate, because, as the Gospel says, every divided kingdom will be destroyed. The Mayorazgo was a Castilian institution, but in other regions of Spain, such as Catalonia, Galicia, Navarre, or the Basque Country, figures such as the Hereu or the Biscayan Troncalidad exist with the same purpose of the Mayorazgo. This is that the assets remain in the family and were not dissipated among the successive children and other descendants. The characteristics of the Mayorazgo were the perpetuity of the institution insofar as the founder and not the possessor, the last possessor, is the succeeded. It's due to the perpetually bond between the founder and the one called to succeed. Then, the prohibition of alienation of the assets, which is not possible to divide. And last, the established order of the succession. Some authors consider the fideicommission to be the origin of the Mayorazgo. One of the greatest exponents of the Mayorazgo, Luis de Molina, pointed out the difference and the similarities between the Mayorazgo and the Roman fideicommission. He established as differences the following. Whereas the fideicommission had to be instituted in a will or in a deed that had the force of the last will, the Mayorazgo could be constituted in a will or a contract. In addition, the Mayorazgo didn't require a third person. Another Mayorazguista, Melchor Pérez de Mieres, who published his work in 1575, when defining the institution, stated that the Mayorazgo is a succession of fideicommission. However, one of the current greatest exponent of the Mayorazgo, Clavero, considers that the doctrine's appeal to the fideicommission legitimates the Mayorazgo. They only appeals to the fideicommission in order to legitimate this, the institution of the Mayorazgo. We cannot fail that the Mayorazgo, like many other institutions, was not born out of the law, but out of the fact of the customs. In the Fuero Real, for the first time in Spain's historical legislation, the figure of cabezales of inheritance appeared, who will the one inherit the ownership of the lands. The institution of the cabezal was intended to keep the lands, which were the testator property, united in the possession of a single person. During the 12th and the 3rd centuries, an essential social and economical transformation happened in Castile due to the increase of in agricultural production. The more efficient distribution of the appearance, the more efficient distribution and the appearance of this agricultural surplus led to the division of labor and the more excellent dispersion of human groups, thus breaking down family and manorial relationships, according to Moreno Núñez. Direct explosion of the land was progressively replaced by a system of leases, exchanges or sales that facilitate the emergence of family production units. This change posed a threat to the lifestyle of the power of the nobility, and they undermined their patrimonial hegemony, which was based on the land ownership and social prestige. The larger a man's patrimony, the greater his influence in social and politics. To prevent the decline of the loss of their patrimony, the nobility needed to fortify his position, and this was the task of the Mayorazgo. The oldest constitutive document of Mayorazgo dates from 1291. King Sancho IV granted in favor of Juan Mateluna, where the essential elements of the Mayorazgo appear. The mayoral affect all his places, possessions, and estates to which his direct descendants will succeed by a way of primogeniture, returning to the crown in absence of this, as Alfonso X and Sancho IV had initially ceded them. The beneficiaries, the heirs, and successive holders of the Mayorazgo were prohibited from selling, exchanging, buying, or disposing them. In that year, King Henry II included in his will a clause confirming all the dominates and grants made by him, with the indispensable condition that they were not to be kept as a mayorazgo and that they were to pass to the eldest legitimate son, the firstborn of the beneficiaries. This asset has to be returned to the crown if the holders died without leaving legitimate descendants. It was not until the loss of Toro of 1505 that the Mayorazgo was officially recognized and consolidated as a legal institution and as a form of succession to the assets of the family estate. Different precepts of this law of Toro regulate the Mayorazgo. The Law 45 of the Law of Toro organized the succession of the Mayorazgo around of the principles of primogeniture and representation. This means that the eldest son is not the first of the living children at the deceased's death, but the eldest descendant in line of progeny in the succession on primogeniture. The line is considered to be first, then the degree, and thirdly the sex, fourthly the age. Depending on whether the primogeniture is followed or not, we can divide into regular mayorazgo or irregular mayorazgo. The Novísima Compilación of 1805 will include the Law 40 of Toro in the Law 5 of the Title 70 on the mayorazgo and other styles of property. Although the will of the founder is the fundamental law of the mayorazgo, there are limits to this principle. Law 42 of Toro establishes that the king's license is necessary to grant the foundation of the mayorazgo. On the other hand, Law 27 of Toro allows the foundation of the mayorazgo without the royal license, as long as it is imposed on the third of improvement and the fifth of the free disposal of the inheritance. Therefore, the royal license is only required when the foundation of the mayorazgo involves succession rights. When the royal license is necessary, the laws of Toro establish that it must precede to the foundation of the mayorazgo, unless being later confirms it expressly. Legally, there were no restrictions for the king to grant the power to found a mayorazgo. In principle, anyone could benefit from this royal license. However, the doctrine insists on the relationship between the nobility and the mayorazgo. The mayorazgo was not only found in the interest of the nobility insofar as it is received with the title of the privilege of the linked property, but also in the interest of the crown, since the mayorazgo was conceived to the payment of right of lands and half-anates that bound this title. From the 16th century until the 18th century, the system of mayorazgo was consolidated. In this sense, during the 16th century, there was a quantitative explosion of Mayorazgo, which continued the blending trend in the following centuries. For these reasons, after the promulgation of the law of Storo, a legal storm was unleashed to regulate the institution and settle down the disagreements generated around the Mayorazgo. The pragmatic edict by Charles V in 1534 was of relevance, which sought to prevent the accumulation of Mayorazgo. The monarch stipulated that if by marriage two bonds were to be united, whose income exceeds in certain limits, they were not to be divided, with the possession of one of the Mayorazgo at chosen, passing to the first-born male, the second son succeeding to the other. On the other hand, under Philip III, the pragmatic law of 1605 was enacted, which attempted to stop the conflicts between women of better lineage and men farther away in the order of succession, defending their rights by their manhood. In the 18th century, the New Enlightened thinkers criticized the institution as a consequence of the conflict between the nobility class and the bourgeoisie, which began to demand a greater liberation of the property. During the reign of Charles III, numerous provisions were enacted on issues related to the Mayorazgo. At the instigation of the Count of Floridablanca, the institution of Mayorazgo was reformed. In 1789, a general reform of the Mayorazgo regime was proposed using the Floridablanca instruction, which expressed the convenience of prohibiting goods from being made perpetually inalienable or unsaleable without royal license, revoking the doctrinal interpretation of the law 27 of Toro. In 1795, the Mayorazgo were taxed with a 50% tax as a compensation for the commercial damage they caused. 3 years later, the sale of the related goods was authorized and new facilities were granted to dispose of the goods. From here until 1820, various regulations were enacted reforming the institution of Mayorazgo. The abolition of the Mayorazgo took place with the Association Law of 1820 during the Liberal Triennium. However, Articles 135 to 139 of the Statute of Bayonne abolished trusts, Mayorazgo, or substitutions whose assets did not produce an annual income of 5,000 pesos. The nobility and war of the dependence opposition paralyzed the decoupling program. The Draft Civil Code of 1851 prohibited in Article 636 all provisions which, all or part of the inheritance is declared inalienable, the purpose of which is to leave all or part of the inherited property to be applied or invested according to the instruction given by the testator. The institution of the Mayorazgo no longer has any effect today, so much so the Article 785 of the Spanish Civil Code establishes that the following shall have no effect. First, trust substitutions that are not made expressly either by giving them this name or by imposing on the substitute party the definite obligation to hand over the assets to a second heir. Second, provision containing a perpetual prohibition or alienation and even a temporary ban outside the limits set out in Article 718. 3. Those which impose on their obligation to pay a particular rent or pension to several persons in succession, beyond the second degree. And fourth, those who propose is to leave all or part of the inherent asset to a person so that they may apply or invest them in accordance with reserved instruction given to them by the testator. The only thing that resembles to the Mayorazgo today is the succession of noble titles. However, as Clavero stated, the validity of the law of Toro in Spain for the assumption of title of nobility does not mean the validity of the regime of the Mayorazgo currently. Both institutions were intrinsically linked, as the Mayorazgo was the necessary economic support for the social prestige required to hold a noble title. According to a judgment of the Supreme Court of Spain of 1984, both elements were so closely linked to the possession of one or more titles depend largely on the economic data of the Mayorazgo. So, as a conclusion, the Mayorazgo was designed to ensure the patrimonial unity of the nobility above all. However, liberal ideas encourage the disappearance of ties and thus the extinction of the institution of the Mayorazgo. It seems impossible that the institution of the Mayorazgo, as understood, can be applied today for preserving the unity of family business and agricultural assets. Thank you very much for your attention.